Welcome to HR ListenIn, the free monthly podcast from the employment team at international law firm Taylor Vinters. We hope you enjoy the show.
Hello and welcome to the latest episode of HR ListenIn. My name's Dom Holmes, I'm an employment lawyer at Taylor Vinters and presenter of HR ListenIn. One of the things we are best known for is helping entrepreneurs and early stage businesses to succeed and achieve their growth objectives. And traditionally, we've helped a large number of startup businesses in the technology market in Cambridge. However, increasingly our focus has spread to similar enterprises in London and internationally. Now, for these growth stage and SME businesses, market competition is fierce, and it's sometimes easy to understand why staff issues feature lower on the list of priorities when they are focused on trying to establish a foothold in the market. So this month, we're going to provide some top tips on managing staff in a growing business. And I'm joined by my Taylor Vinters employment team colleague, Kim Wedral-Rooke. Now, Kim has a real interest in supporting businesses as they grow from concept to market and beyond, so she's really well placed to pass on her expertise. Welcome, Kim.
Thanks, Dom, and hi everyone. Yes, in my experience, there is often a temptation to push HR matters towards the bottom of the pile. And when issues do arise, they're dealt with reactively, that is, only when they've reached a difficult point.
And why do you think that is, Kim?
Well, put simply, Dom, it's difficult to find the time or cost to invest into a staff agenda when there are often other more pressing commercial imperatives to focus on. The staff issues simply sometimes can be seen as an unwelcome drain on already limited resources.
So I guess it's our job to correct that misconception today.
Yes, I think so, to an extent. It will almost always be the case that investment in HR matters will be competing for budget with other forms of business expenditure, and that budget is obviously much more limited when businesses are getting off the ground. Though in our experience, growth stage businesses can benefit from having a clear approach to managing staff issues at the outset. Really being prepared to manage these issues early on can save companies time and cost further down the line.
And make them more attractive for investors, presumably.
That's right, yeah. Good HR practices and procedures can certainly help to project an organised and slick operation, which could be a real selling point when dealing with investors in subsequent funding rounds or potential buyers of the business, for example.
Okay, so let's start with tip number 1, and this is all about knowledge.
Yes, Dom. Many growth stage businesses will not have any dedicated HR function. So I think it's really important that the management team has a basic grounding of what employment issues could arise when they take on staff, and equally if they have to part ways.
But how do they do that in practice, Kim? I mean, as you've already said, time and resource is often stretched in these types of organisations, particularly at a senior level.
Well, I'm certainly not saying that management need to have HR qualifications, but the way to approach it is to look at some business critical scenarios. Really ask yourself, if someone behaves badly or is not performing well, would I know how to address my first disciplinary process? If someone raises a formal complaint about being bullied, how would I handle that? If one of my key staff resigns but has access to or control over our confidential information and IT systems, how do I deal with the potential business risks?
And many of those issues will require some bespoke legal advice, particularly where there is a wider commercial or reputational risk to the business. But are there things that growth businesses can do to help them start answering some of those questions?
Well, some basic training is almost always a sound investment. There is, of course, a wealth of information on the internet, but it's sometimes out of date or inaccurate. The ACAS website is a good starting point for the absolute basics, but in my view, there's no substitute for a few hours of training to arm managers with the tools to deal with these tricky situations. We do this kind of thing all the time, and the feedback is that it's very worthwhile and cost effective.
Okay, so that's knowledge. Moving on to our second top tip.
Well, this is all to do with procedures, and in many areas employment law dictates that appropriate processes must be followed. For example, when dealing with disciplinary issues, grievances, and redundancies, failure to follow due process and jump through the right hoops in the right order creates avoidable risk for businesses. In other areas, policies and procedures are not essential, but they can be very helpful in setting appropriate boundaries of behaviour and creating the right workplace culture. So, for example, many employers have an equal opportunities policy, setting out a firm stance on tackling potential discrimination or harassment issues.
And in my experience, I think a good equal opportunities policy backed up by some basic training for staff is often invaluable in helping to defend allegations of discrimination when they do arise.
Yes, really the key is to balance appropriate policies and procedures which clearly set expectations whilst preserving as much flexibility as possible. Depending on your business and potential areas of risk, some types of policy will be more appropriate than others. For example, a social media or IT usage policy, for example, could be quite useful to technology companies.
I think it's clearly important for businesses not to get too bogged down in introducing lots of written rules for staff. My sense is that a lengthy, detailed handbook is probably not necessary for most startups, but a small suite of essential policies should always be considered. Okay, so far we've done knowledge and we've done procedures. Let's consider tip number 3, Kim.
Well, third on the list is proactivity, and this ties in with what we have discussed in relation to good management and training. Prompt attention to issues as soon as they arise can often resolve and prevent them from becoming time-consuming disputes. If there are problem areas, for example workplace conflicts, personality clashes or poor performance, do not let them stew.
I think that's really important, and when I give training to managers at any size of organisation, the key message is always to ensure that problems are nipped in the bud. And there are typically 3 stages. So stage 1 is obviously resolving things informally. Stage 2, you might have to go through a formal process if that hasn't worked. And stage 3, which is what we call the red zone, is litigation. And as you progress through those various stages, cost and risk escalate in terms of management time, disruption to the workforce, reputational risk, getting lawyers like us involved, of course, and potential financial compensation.
I do agree, Dom, and very often a 5-minute chat can go a long way. Tensions dissipate, performance or behaviour improves, and the business gets on with doing what it does best. And arguably this is especially critical in early stage businesses where even minor problems and tensions will be more evident and will have a sort of closer to home impact on remaining staff.
I think for me, proactive staff management is again all about balance. You need to be firm and win respect from staff, but also approachable to enable you to win trust and buy-in. And that's not always easy to do in practice.
No, I completely agree, and there's much to be said for doing the basic things well. And by this I mean addressing minor behavioural issues such as poor punctuality or inappropriate banter, and also learning how to identify possible causes of workplace conflict.
And what do we think those causes might be then, Kim?
Well, commonly, for example, it might be a change in team environment, which may be disrupted by the impact of leavers or new joiners. It could, for example, be a change of line manager, particularly if the new manager takes a tougher line on things that were previously dealt with more leniently. It's also being aware of any cliques or potential personality clashes within a team and keeping a close eye on those. And again, proactively anticipating these issues and intervening early is important.
I think that's definitely right, and if left unchecked, there's often a spiral effect which leads to allegations of bullying or harassment, employees taking time off for stress, and potentially resignations and claims. Well, that I think brings us neatly onto our 4th tip.
Yes, well that's effective communication, which is really important at an individual level and a wider business level. I think it's particularly important for early stage businesses to communicate with staff over business plans and objectives, the role they play in achieving those objectives, and importantly, why. Staff often feel more bought in and keen to grow the business if they know where it is going and how they fit into that framework.
And Kim, have you got any tips for how to do that in practice?
Well, some employers favour sort of regular email updates, for example, a bi-weekly bulletin outlining key successes, applauding individual contributions, and outlining upcoming events and future strategic initiatives. This can also be a helpful platform as and when trickier communications might be required with staff.
Yeah, and I think we'll come on to that shortly. And what about communicating with individuals specifically?
Well, Dom, it sort of goes without saying that on many occasions the ability to contain any potential conflict or controversy will lie with the messaging. For example, if you want staff to travel to business on short notice, a sensitive approach may be required to get their buy-in, particularly if they have other commitments that might be disrupted.
And in terms of other forms of communication, in our experience, some managers struggle with providing constructive feedback to employees who have strayed from what is expected or acceptable.
And I agree that that's not always easy in practice, especially if you're not used to having those types of conversations. It is really important to bear in mind that what you're trying to achieve, though, and normally providing feedback is all about modifying the employee's behaviour and improving performance, not to vent emotions or punish the employee. Again, dealing with issues as they arise helps maintain high standards and avoid surprises later on.
And it's just a point I want to add there, Kim. I think it's also important to avoid giving glowing appraisals for poor performers. And honesty, I think, is always the best policy. It sounds really obvious, but I've seen it many times when employers come to us asking for advice on more formal steps to manage an employee out for poor performance.
I do really think that's right. And do you know of any sort of practical tips for approaching those difficult conversations?
Well, I think a face-to-face conversation is always best. I would say, get to the point quickly, explain the problem assertively, clearly, and very importantly, don't apologise for it. Listen to the employee's version of events and any mitigating factors. Explain what steps need to be taken to remedy the issue and agree these with the employee if possible. And I think if you have to give criticism, I would criticise the action, not the person themselves, and then always end the conversation on a positive note.
And of course, taking a really good note is also really important. So my fifth tip really is all about evidence. And in the unfortunate event that a dispute can't be avoided, evidence is really critical. So make sure you have a paper trail of discussions that you have with staff on these types of issues. For example, if you've had an informal discussion with a member of staff about unsatisfactory performance, send a brief follow-up email outlining what was discussed and any action points or remedial steps. This will be invaluable if there is a later challenge or a need to move things to a more formal footing.
Okay, Kim, so on to our final tip, number 6, and this is all about framing the employment relationship in the right way so that your business interests and the ideas you are developing are properly protected.
Yes, that's right. And although trust is obviously the foundation for good staff relationships, it is crucial for businesses to build in appropriate protection in the unfortunate event of a breakdown in that relationship or an unexpected departure. And getting the initial engagement right and setting clear expectations immediately is vital.
And what we're talking about here is investing proper time in sorting out the employment contract to protect the business from potential threats.
Yes, you do really need to consider your documentation. Would you benefit from clear confidentiality and IP protection, for example? And do you need restrictive covenants to protect your business if a key employee leaves? Do you need a clear policy on acceptable IT and social media use if that is important to the business?
I think the importance of comprehensive protection in employment contracts cannot be underestimated, particularly in the early stages of a business where there's a lot of development work going on and a lot of revenue generating ideas being floated around.
And this really is the kind of thing that investors will be really interested in. It's often when a business is most vulnerable, employees come in to assist you in realising your ambitions, but that brings with it potential risks as well. They will need access to highly sensitive information, for example, to your client base and business contacts, your financials and pricing models. And for this reason alone, it's rarely worth the risk of cutting corners when setting the contractual relationship between parties.
Okay, so let's start with protecting confidential information. Even if there's no written contract in place, the law does provide employees with a little bit of protection.
Yes, that is right, Dom, but it is quite limited. And during employment, employees are bound by an implied duty of fidelity and an obligation not to misuse confidential information. However, I think employers would be well advised to have a detailed confidentiality clause in all employment contracts, making clear exactly what information is deemed confidential and precisely what the employee can and cannot do with that. If the contract is silent, there is a lot of scope for arguing over these points, so why take that risk?
And it's especially important, I think, when we come to looking at protecting confidential information after the employment relationship has ended.
That's right. I think if there's no confidential information clause in the employment contract, the law will only protect a narrow category of trade secrets after employment has ended. Everything else is fair game, really. And the employee can use it as he or she wishes, even if it retains a degree of confidentiality. So again, why take that risk? And also, a detailed confidentiality clause sends the right message to employees. This is how important the information is to our business, and this is how seriously we would view any breach.
Okay, Kim, so what about intellectual property?
Well, the general principle, Dom, is that the IP rights in anything created by an employee during the course of employment will automatically vest in the employer. However, for IP-heavy businesses, again, it makes good business sense to spell this out in the contract and ensure any potential loopholes are closed. It just prevents arguments and uncertainty further down the line. And also, if individuals are working for you on a consultancy basis rather than as employees, any IP will need to be expressly assigned.
And what about restrictive covenants, by which I mean sort of post-termination restrictions, non-compete, non-deal, non-solicit obligations, that kind of thing?
Well, these might not be appropriate for all employees, but should certainly be considered for key individuals. And the starting point really is that they're only enforceable to the extent they are reasonably necessary to protect the business legitimate interests. And that is its sort of confidential information, customer base and workforce stability. In practice, this really means two things. One, they need to be drafted as narrowly as possible with regard to the length of time, geographical scope, and the precise activities that are off limits.
And just to come in there, Kim, we're often asked how long covenants should last for. As a rule of thumb, I think the absolute maximum is 12 months. I have rarely seen anything above that be upheld, and often they are staggered. So, for example, an employer may have a 12-month restriction on soliciting customers, but a shorter restriction on working for a competitor altogether, say maybe 6 months, simply because by its very nature a non-compete is more onerous. And if you can live with less than that, say sort of 3 months non-compete or no non-compete at all, then I think so much the better.
Yes, I agree with that, Dom. And the second issue, and this is often a difficult one for employers, is that the restrictions should be bespoke to the relevant employee.
And that's a very important point, and we're often asked to produce template, generic, restrictive covenants which are then just cut and pasted into every employee's contract. Now, whilst they may have some sort of deterrent effect, they are unlikely to be enforceable.
Yes, you really do need to look at the specific employee you are restricting. What threat do they pose to the business if they leave? Do they have the opportunity to walk off with confidential information that can be used by a competitor? Do they have deep relationships with customers that you risk losing? And might their departure encourage other employees to do the same, perhaps as part of a team move?
So I think the message is, if you're serious about putting in place effective protection, it is worth tailoring the covenants in each case. And whilst we can never guarantee that a restriction would be upheld if a court was asked to grant an injunction for you, it does give you a much better chance. Well, that's about it for this month. Kim, it's been great to discuss these issues with you, and there's clearly much food for thought there for entrepreneurs and startup founders. If our listeners want to get hold of you to discuss this in more detail, please could you remind them how to do that?
Yes, thanks, Dom. All of my contact details are available by searching for me on the Taylor Vinters website, which is www.taylorvinters.com. Or you can reach me on my email directly, which is kim.wedral, which is spelled W-E-D for Delta, R-A-L for Lima, -Rooke, R-O-O-K-E, @taylorvinters.com, or via LinkedIn.
Thanks, Kim. Next month, I'll be joined by another member of the Taylor Vinters employment team to discuss more practical HR issues. You can access all previous editions of this podcast by clicking on the ListenIn icon on our homepage, where there are direct links to the web pages of all of the presenters. And for those of you who are active on social media, you can also find me on LinkedIn and on Twitter @DomHolmes147. Thank you for listening in to HR Listen In.